Join us for Legally Adulting.
Adulting is not supposed to be easy.
What are the questions and concerns that we as young people have about living through a pandemic?
Hello to our lovely audience. Thank you so much for joining us for Wise Law's Legally Adulting seminar today. My name is Simran Bakshi, and I'm here with my colleague Paul Adam, and we're both associate lawyers at Wise Law.
Wise Law is primarily a litigation firm. Litigation is a general term that we like to use to refer to any kind of legal problem that requires some sort of a dispute resolution, whether that's through the court system or dispute resolution through mediation, negotiation, discussion to come towards a mutual solution.
And the kinds of disputes that we typically assist in can range anywhere from, a dispute that involves employment, your family, maybe a commercial contract, a dispute with a neighbor, privacy issues, human rights problems, and the list can go on and on.
And we also do a good bit of non-litigation work too, like will drafting, estate administration, employment agreements, and incorporations.
Now, we invited you here today as fellow professionals to share a dialogue of what it means to be an adult in 2021 and how we go about building relationships with fellow professionals. And one important person can be a lawyer as well. And that could be of assistance in terms of helping you with some of the questions that arise in this phase of your life. We also really wanted to get into what a relationship with a lawyer can look like and address any of the basic questions you might have about how to start to build that kind of relationship.
Oh, sorry, I think my video cut out for a second. But to Simran's point, what we're trying to do is make it easier to become we're trying to make it easier to become a more fully fledged adult here in the year 2021. And it feels like it gets harder every year with the pressures that are mounting during this pandemic, to try to take some of the work of being an adult off of your plate and put it onto ours. We feel like the easiest way to become fully to feel like you're making the transition towards adulthood in your own life is by being able to tackle all the problems that you want to tackle yourself. And that often means hiving problems off to other professionals who can help you solve some of those problems for you. And that's what Wise Law is here for, to take the problems that fall into the legal arena and help you work towards solutions to those problems that you don't necessarily have to implement step by step yourself, but that instead you can entrust somebody else, like a lawyer, to handle for you.
And like Paul says, to us, what an adult means is just having confidence about the decisions that you're making about life. We go from deciding, what courses we're going to take in university to suddenly having some really important decisions to be making that can really impact the direction that your life takes. And you want to be able to feel good and confident about what the decision is that you're making. And a big part of that is knowing when to reach out to ask for help, whether it's from a lawyer or another professional in your life. So that's what we really wanted to come here today for, is to get some discussions going on some of the legal questions that you might have at the back of your mind that you want to figure out some solutions to.
Yep, and we've been doing these legally adulting sessions across the GTA for the last year, and until we can do them again in person, We're hosting these sessions online where we can talk to you and you can talk to us, and we can find out what's on everybody's minds, what is keeping people up at night, and what kind of questions do people want input from a lawyer or another professional on in order to get some clarity about how to move forward through the world.
So our plan today is to really tailor this program to your specific questions. So feel free to submit in any questions you might have using the chat function. We've already got quite a few questions from you guys beforehand, so thank you for that. We're going to do our best to get to those as well. But if anything comes up along the way, feel free to just let us know, and we'll definitely try to get to them. Guess on that note, we can probably just jump in. So Paul, I guess one question that has come up pretty much every single legally adulting seminar we've hosted is, how do I know when to get a will? And more importantly, how do I know that the will that I have or that I get is going to be valid?
So those are two really interesting questions that have answers that can sort of take you off in two different directions. One of them involves thinking about what the circumstances are in your life right now that need to be addressed, that are maybe different um, from where they were at a year or 5 years ago. And the second question about how do I make sure that my will is valid is really about putting yourself in the shoes of somebody who will be looking back at this moment in time on your life after you've died. So in order to think about whether you need a will right now, it's important to ask yourself, do I have next of kin or loved ones who would need to be taken care of if I pass away? If there are people like that, and almost everybody has somebody like that in their life, the chances are you should be making a will to help um, smooth out the process of caring for them after you're gone. And if you need a will right now, um, if you're wondering if you need a will right now, you should think about, has it been a long time since I've come up and made a plan with how I'm going to care for the people in my life in the event that I'm not there anymore? Has the number of people in my life changed? Do I have a spouse now where I didn't have a spouse before? Do I have children now where I didn't have children before? Do I have a parent who's old now and in need of care where I didn't have a parent in that kind of situation before? Those are all situations in which it's a good idea to get a last will done. And what I'd add to that is, if you have the presence of mind right here, right now, to sit down and think about whether you should be making a will and whether you should be contacting a lawyer to make a will, it means that there's no time like the present, because no matter what, your life is going to be busier tomorrow than it is today. And there's no better time than right now to take advantage of what little free time or downtime you have to spend some quality time thinking about this process and deciding how you want to plan for your family and your loved ones.
It's really good to know. And you mentioned relationships, and considering who you've got in your life and what that really looks like in terms of providing for them. And I'm just wondering, are you required to be leaving a part of your estate to a certain family member, like a spouse or a child, or is that more a personal choice?
Um, it's a little bit of both. Classic lawyer answer. Um, Everybody in Ontario has the right to name anybody they want to be an heir of their estate. The trade-off with that is that whoever you name to be an heir under your last will, you still need to provide for the people that you provide for during your lifetime. So if you have a spouse that's financially dependent on you, whether you want to or not, you need to make some provisions for that spouse after you pass away through your estate. Likewise, if you have children who are financially dependent on you now, if you don't provide for them in your last will, they may have the right to request that a court make an order that they get financial support out of your estate. So you can name anybody you want in your last will, but you can't run from the financial obligations you have right now. In addition to that, if you whatever you leave your spouse in your last will, your spouse has the right within, I believe it's 6 months of your death, to decide whether he, she, or they is going to take what you left them in your last will, or to take what they would be entitled to if your date of death hypothetically was like the date that you separated from them, and you started to end your marriage. Simran, you know more about separation than I do because you're our resident family lawyer. So you can talk a little bit, I think, more expertly than I could about what happens when two spouses separate, what they're entitled to in terms of divvying up the family asset. But whatever you tell me in your answer, I would tell you retroactively. That's what my answer was to the question of what your spouse can get from your estate if you decide, with the freedom that you have in Ontario, not to name her in your will.
Yeah, it's an interesting intersection of the law because in family law, when a spouse, and this is not in the context of a separation, just in general, when a spouse passes, you've got the right to make an election to either receive what's provided for in their last will or to ask basically the court to figure out a calculation of what an equalization of assets would look like. An equalization is basically a concept in the context of a separation where the net equity each spouse accrues over the course of the marriage is calculated, and then the party who's benefited financially the most would provide the other an equalization payment so that both spouses walk away completely equalized. And so it's interesting to see that option being provided in the event of a death where you get to choose, which one's going to work out best.
So interesting. Yeah, there's so many intersections between family law and estates. One thing that's come up for me, and maybe this is a question that we can come back to a little bit later on, is, if somebody has made a last will and the last will doesn't provide enough support for a child, do you calculate the child's support the exact same way out of an estate as you would in the event of a separation? And I've found that it's not exactly the same, and the principles behind it are a little bit different. But it's so interesting the way family law ideas influence the way we do estates here in Ontario. But switching gears for a moment, I had a question for you that came to us before today's session. When we first started doing these legally adult sessions on Zoom as opposed to in person, there were a huge amount of questions about the pandemic, and initially a lot of the questions were, am I forced? Can I be required to come into my workplace even though there's a pandemic if I'm afraid of catching COVID-19? Now we've gotten a lot of questions about vaccines and the interplay of vaccines and employment law. So, Simran, I would love to hear your thoughts on this. Does somebody need to get vaccinated? If somebody's employer is asking them to get vaccinated in order to continue their employment, are they required to comply and get vaccinated in order to come into work?
It's a really interesting question. And honestly, it's come up, I can't tell you how many times over the past month, because everyone is there's vaccination anxiety going on. Do you or don't you? What's it going to look like if I don't get it? And what happens if I do get it? And we're seeing questions start to come up in employment law, like you've mentioned as well. And I'm going to give you the lawyer answer, which is it kind of depends. And quite honestly, I don't think we really even have a concrete answer as of yet. But if I were to guess, I think we're heading in the direction where an employer asking employees to be vaccinated may be permissible, but it will likely depend on the type of the employment and the nature of the employment. And the reason I say that is there's already some sectors where vaccination is mandatory, where you've got people working at long-term care homes, or with children in schools. Like certain types of professions already have a certain amount of expectations of vaccines. And if you're working with a vulnerable section of the population, chances are it's not an unreasonable request of an employer to ask that you be vaccinated for the safety of other employees and clients and customers that you're going to be dealing with day in and day out. But then you also have to have that intersect with somebody's right to autonomy and privacy. So I don't think we know an exact answer as of yet. And I think we're going to see more nuanced answers come up as the case law evolves on this. But if I were going to lean in one direction over the other, I would say I would think that if the circumstances of your employment would justify it, I could see that an employer asking an employee to be vaccinated to be reasonable in certain circumstances.
And what would happen, I'm curious, if the shoe was on the other foot? If you were in a situation where you had gotten vaccinated and you wanted your coworkers to get vaccinated, but your employer didn't seem to be forcing your other coworkers to get a vaccine, and you felt like you had the choice between either returning to your job in circumstances that felt unsafe to you, that might genuinely be unsafe to you, or being forced to quit your job. Like, what could you do in a situation like that?
It's Again, it's a really interesting question, and I don't have a specific answer for you. But what I would point you to is just the Occupational Health and Safety Act, which provides that an employer must ensure that employees have a reasonably safe and healthy work environment. But by the same token, when we're talking about vaccinations, by being vaccinated, you've kind of provided yourself with a certain degree of protection. At least that's what we're being told by public health officials. So whether another employee's decision not to be vaccinated is putting you in an unsafe position is kind of the crux of the question here. If it's reasonable to assume that you're at a higher degree of risk, either based on how closely you work with this other employee, their outside activities or their activities through employment, then possibly that puts you in an unsafe position. But it really depends on that, and that's when the Occupational Health and Safety Act would kick in. But with the OHSA, you can basically refuse to take on work, but what this triggers for the employer is a duty to investigate, not necessarily a duty to make a mandatory policy for all employees to be vaccinated. And once they investigate the matter further, they'll look into whether there is a legitimate safety concern, and what are alternatives for making sure that the employee can ensure that they've got a safe work environment. And it doesn't necessarily mean asking the other employee to be vaccinated.
Interesting.
Yeah, well, jumping back, I know we've got a whole long list of estate questions for you. This question's come up quite a bit, and it's how much does an estate have to be worth for it to actually go into probate in Ontario?
So this is such an interesting question because it involves equal parts of what the law says in Ontario and what places like banks, insurance companies, and other third parties do, regardless of what the law says. There's no specific rule in Ontario about how big an estate needs to be in order to go through probate. There is a rule about how big an estate has to be before you have to pay probate tax on it, but that's a different matter. In theory, if a loved one of yours dies and they have money in a savings account at the bank, and there's no other person to co-sign on that bank account, the bank, even if there's only $1,000 or $2,000 in that bank account, could in theory lock the account, say the account owner has passed away. It is our policy that we can't release the funds in this account to the next of kin until the estate is probated and somebody is fully appointed as the executor of the estate formally by the court. So get back to us when this estate has gone through probate, which means you've applied to court, you've gotten a court to sign off on a certificate saying that you are the legal representative of the estate, and a bank, insurance company, whoever else has the authority to deal with you and you alone as the representative of the estate. There's absolutely zero guidelines, practically speaking, as to when a bank can and can't say that. It's something that happens, in my experience, almost exclusively based on the bank's internal policies around fraud prevention, loss prevention, and sort of customer service standards. And the fact that there isn't one standard about this in Ontario makes it really, really difficult for people to deal with banks, because oftentimes for very small amounts of money, when a deceased person only has two surviving relatives, and they can prove that they're the only two surviving relatives, and they can prove to the branch manager at the bank, because they've both willing to sign a paper saying we're the only two children of mom, and we just each want half of the money in the bank account, can you please release it to us? You can make the argument that there's no real common sense reason for the branch manager not to release the money to them, particularly if, for instance, they were willing to sign a paper that said, we'll indemnify the bank and we'll be responsible for any losses if some third child comes out of the woodwork and say, hey, I had some of that money in that account belonged to me too. But it doesn't work like that. And we find that a lot of times people aren't able to get access to their money unless they go through probate, when the cost of hiring a lawyer to submit the probate application would be almost as expensive as um, as there is money in the very small estate. So it's a
But
problem that leaves a lot of people flummoxed.
yeah, I'm wondering, is it because there's concern that the deceased might have had certain debts or liabilities that need to be like, is that what the rationale is? Or
The rationale from
oh, I think we're losing you, Paul. Well, we might have to hold that thought until Paul gets
perspective
back.
is often oops.
Yep,
Okay.
if you don't mind repeating it, you just got cut off at the beginning.
What I to say, the thing that I wanted to say is this. Can you hear me now?
I can hear you.
Okay. So the thing I wanted to say is the bank does this as a cover your butt exercise. The number one thing that your big five bank here in Canada, to say nothing of like a smaller agency, wants to be left with is a situation in which the deceased person, yeah, owed money to, like, let's say the CRA, and they just release the money to the next of kin. But also they don't want to be in a position where, let's say a person passes away and the one person presents himself as the deceased person's son. And he says, this is my dad, I'm his only son. Um, I don't have any other siblings. Can you please release the money to me? And the bank goes and writes him a check, and then he takes the money in the account. And then 2 weeks later, another person shows up at the bank, and she says, I'm so and so's daughter from his first marriage, and I'm entitled to half of the money. I'm in this account. My half brother is entitled to the other half of the money. Can I have it, please? And the bank manager says, oh, no, I just gave all the money away to the half brother, and now this person's going to sue me. So that's what the banks don't want to that's a situation that the banks don't want to be in.
Does it work the same when it
And
comes to like private? Like if I'm selling a car, or if someone dies and they leave their car and they're the only owners of that car, can the spouse just go out and sell it to a private, through a private sale, or does that also need to be subject to probate?
um, often it doesn't. We have lots of files where somebody comes to our office and says, my mom passed away. She didn't own a lot, but she had this car. Can I just uh, transfer the car to my own name? And what we've done with clients is we've been able to prepare a letter saying, basically reporting to this client, you've introduced yourself to me. You say that this person was your mother and that she's passed away, that her only children are you and your sister. And your sister has provided me with a signed consent uh, that says that, I consent to my mom's car being put in Charlie's name and not mine. And on the basis of that consent, I'm satisfied, and the law says that you would be entitled to take that car for yourself. And then we've provided that documentation to clients, and they've provided it to the Ministry of Transportation, and the Ministry of Transportation has allowed them to change the name and the title on the vehicle. In a situation like that, I guess because the MTO is confident enough that nobody is going to be able to sue them in a situation like that, they seem to feel comfortable doing that. The exception to this rule, the main reason that people do wind up having to get probate, even if their banks are compliant, is that in Ontario, it is not lawful for you to sell a house that belonged to a deceased person if it's still in the deceased person's name, except for very rare circumstances. And the only way, usually, to change the name of the title of the property from the deceased's name to your name so you can sell the house is for you to be appointed as the executor.
Yeah, that makes a lot of sense. Sorry, I'm just going through our
Um,
list here.
yeah, I had another employment related question for you, Simran. Um, and this is not necessarily COVID related. This is, well, it's partly COVID related, although this is a kind of scenario that I think has existed for a long time before the pandemic. Let's say you're in a position where uh, you're coming back to work after being furloughed during the pandemic, and your employer tells you that, they've they've had to downsize your position because they can no longer afford to keep you in that position, and they're terminating your employment, and they're offering you some severance, but you suspect that really this wasn't to do with the pandemic at all. They wanted to terminate you for another reason, and they're just not saying what it was, and they're using the pandemic as a convenient excuse to lay you off. Um, in a situation, are there any rights that you have? Is there anything additional you can do to collect additional money in compensation for being let go?
Yeah. Well, it's a loaded question, and the first thing to really figure out is why were you let go? For the most part, when we talk about a wrongful dismissal in Ontario, we're referring to whether you had enough notice that your employment was going to be terminated. If you weren't provided with any notice, or if you weren't provided with enough notice, that's when the termination becomes wrongful. But in certain circumstances, if you were let go for a reason that's discriminatory under the Human Rights Code, or amounts to reprisal because you filed a complaint about your manager who was bullying you, like there are circumstances where the why is very important as well. So if you suspect this really has nothing to do with the pandemic, really it's because I told them that I have a disability and I needed to come back to work gradually, you could have more recourse than just what you would be finding in a wrongful dismissal. But let's assume it might not be COVID related, but the company's coming to realize they don't need half the workforce they had, and they're letting you go because of that. An employer does have a lot of discretion to reorganize their workforce, and terminate or rehire or whatever the case may be with its workforce. So long as it's not discriminatory, or some kind of reprisal, as I mentioned. So if that's the case, the question really becomes: were you provided with adequate notice of your termination? And if they basically said, in 2 weeks your employment will end and you were working there for 20 years, chances are you have quite a bit more in terms of entitlements than what you've been offered. So what I would strongly recommend you do is, regardless, speak with a lawyer, go over the severance proposal that's been put to you. The lawyer is going to probe you to find out what the circumstances surrounding your termination was and see if there's any possible recourse beyond that. But the first step would be to speak with a lawyer and just make sure you've got a copy of any employment contract you've signed and a copy of the severance proposal available for the lawyer to review, because that's kind of what we need to assess how fair this proposal is.
And what happens in a situation like that if you didn't have an employment contract? If you never like really made a contract with your employer about what your rights were going to be if you got laid off? Does that mean that you just like don't have recourse at all, or what happens
Yeah,
there?
yeah, people seem to assume that that's the worst thing ever if they don't have a written employment contract. And really, it's kind of the opposite. So your employment contract tells you exactly what you said. What is your rights? What are your obligations? Most often an employment contract will include a termination clause, which really more protects the employer than you. The employer is essentially saying, if we terminate you, here's what we're all agreeing that will happen in those circumstances. And typically what they'll say is, we're just obligated to give you the very minimum amount of notice that the law says we have to give you. Where that kind of language isn't included in the contract, the courts get to decide what are your entitlements. And the court standard, what we call common law standards, are way more generous than what employers tend to provide for in their own employment contracts. So in the context of a termination, not having an employment contract is actually a very positive thing, because it allows you right off the bat to say, there's no termination clause that defines what my entitlements are, so it's going to be the common law standard. The courts get to decide. And their standards tend to be about a month per year of service. I'd say 2 to 4 weeks per year of service. The more senior you are, the higher that would be. And the more long-term you are, the higher that would be. So, Paul, while I have you, I do want to jump back to some estate questions as well. Okay, so we've talked about probate, and you actually brought up some things about just, in certain circumstances, if the house is not in your name, it'll go to you. It might have to go through probate so you can sell it. And I'm just wondering, it got me thinking, is there a way to plan for your estate so that the people you're leaving behind don't have to go through that process of probate? It sounds pretty onerous.
Yeah, it's a really good question. The $64,000 question when it comes to estate planning is always, and I think that this is something that's really important to talk about with your lawyer or your estate planner when you're getting into the process of planning your estate, is, I may want a last will with all the bells and whistles that set up corporations and trusts and all of this stuff. But the key question always has to be, is this going to make it easier for my family to manage my estate than a simple last will? And is this going to really save me money in the long run? And if so, how much is it really going to save me? The reason I say that is because, unlike some of the many tax burdens that we pay here in Canada, the amount of money that you pay in estate tax is not that enormous. A lot of estate planning is designed to kind of get around the need to pay probate tax, if not the need to go through probate at all. And probate taxes are only about $15 on every $1,000. So in other words, 1.5% of your assets for everything above $50,000. Um, that's not a huge amount of money. The other reasons that people decide to do complex estate planning are if they have a huge net worth. But we're talking about, into the several millions of dollars. And when even 1.5% of your net worth is going to be a very large sum of money, but even more so in cases where um, you have family businesses or family trusts or a family corporation, and the process of having to put the brakes on those businesses, doing any work or getting anything accomplished while the estate goes through probate will cause you a huge financial loss. Um, or a scenario where if you don't if um, if you don't plan your estate effectively, property is going to have to be sold, or stocks and other assets are going to have to be sold when you die, and the sale of those is going to trigger a big capital gains tax that your estate is going to have to pay. Um, and so there are ways that you can plan to avoid the capital gains tax hit. The biggest one, the one that everybody can take advantage of, or almost everybody can take advantage of, is where it's feasible. Um, if you own and live in a house jointly with your spouse, it's a good idea for both you and your spouse to be joint owners of the property. Now, there may be other reasons and considerations for why you don't want to jointly own that property. For example, if your spouse is a citizen of the United States, there may be tax consequences to her or him owning a property in Canada. But strictly for estate planning purposes, the best way to avoid the biggest capital gains tax, which is usually going to be on having to sell your house after you die, is making sure that the house is in the name of your spouse on your date of death. Um, if you are older and your plan is that after you die, um, your house will pass to your children, you can also help avoid paying estate tax, although you can't necessarily get out of the capital gains tax issue if you also put your children on the title to your house together with you and your spouse. Don't do any of this without speaking to a lawyer. It's always a good idea to speak to a lawyer about making any of these decisions, because there could be positive or negative consequences to doing it that we're not discussing here today. Don't take this as legal advice, but that's the biggest way that you can avoid having to pay probate tax and possibly avoid having to pay capital gains tax on your house. The other slightly more exotic way that you can avoid probate and avoid having to pay capital gains tax is if you own more than one house, or if you own a really large, have like a really large amount of money in investments, um, or if you have a lot of business interests that are in, have a lot of intrinsic value, like the business owns property or it owns the rights to patents or the rights to certain distribution rights that are themselves worth of valuable money that could be sold on the open marketplace. You can pass your business and those assets through what's called a secondary last will, which is, like the name would suggest, literally a second last will that you have. And with your second last will, you lump all of your assets that will not require probate, which includes corporations that you own, um, property that doesn't require um, a change in title in order to pass to new owners, because you own the property through a holding company, and instead of changing the title to the property, you can just redistribute shares in the holding company. All of that stuff can be put in your second last will, and then that second last will doesn't have to go through probate. That's what's called secondary will planning. And then just the assets you have that will require probate, like for example, bank accounts that are in your name and in your name only. And going back to our discussion earlier today, your bank is not going to allow your next of kin to get access to unless an executor is appointed as your trustee. Those assets and those assets alone go into your primary will, and that's what gets probated. And then you only wind up probating a portion of your estate.
So you mentioned corporations, and I'm just wondering, so if a corporation, all the bank accounts, all the assets and liabilities of the corporation, that can pass without going through probate, is that right?
Well, for small, tightly held corporations, that is often, not always, but often the case. Because what can happen is, unlike a house where in order for the house to have a new owner, the legal title to the house has to be changed, and that change needs to be made through a registry system. In a corporation, um, shares in a corporation can be transferred from one person to another person without you necessarily having to register the change through a government agency that requires probate. And
That
that
makes
means
sense.
that, effective control of the corporation can change from the old owner to the new owner without you necessarily requiring, like the corporation can just pass a new bylaw that says, it used to be dad was the director of the corporation. Now Simran is the corporation. And then the bank doesn't have to take the court's word for it that Simran is the new legal representative of the corporation. The bank can just see that the corporation has passed a new bylaw. The bylaw is allowed under the Business Corporations Act in Ontario. And that means that the bank can say, okay, corporation says Simran is the new director. I can take instructions from Simran and I can do this and that to the bank account.
It's
So
really interesting.
that's, in a nutshell, that's the big difference.
Yeah, there's so much to consider with this, eh? It's one of those
Yeah,
things you've got to
this doesn't
carefully.
this doesn't always, one of the reasons it's so important to talk to a lawyer about these changes is that a lawyer can tell you not only what the upside is to these changes, but what the potential downside is to your estate, to your family and loved ones, if for any reasons the changes don't work. If my secondary last will, for whatever reason, it's determined that it does need to go through probate after all. Is there a potential downside there? Does the size of the downside and the likelihood that it may happen outweigh the potential upside of you doing it this way? Because none of these sort of upper tier estate planning solutions are guarantees that your estate is going to avoid any tax liability whatsoever.
Right.
There's always a risk that tax penalties are going to be, that there are going to have to be tax consequences to the estate, and there's always a risk that you won't be able to avoid probate 100%.
That makes sense. And I guess it gives you an opportunity to really tailor your specific situation and take advantage of whatever might be applicable for you.
Yeah. And
Mhm.
the other thing to think about is that if you are ever in a situation where you worry that somebody may challenge your right to distribute your estate the way you're distributing it, kind of touches on the question you asked earlier about the validity of your last will. A lawyer can help you think about, when I'm planning my estate in this way, how do I do it in such a way that will make it less vulnerable to will challenges when I die?
Yeah, that makes sense. Okay.
Um, so let me ask you another employment related question.
Sure.
And um, this one is really has nothing to do with the pandemic directly at all, although I'm sure there are some wrinkles in your answer that are going to be new. But if you've been offered a new job, what are the most important things to look for and to be worried about in your employment contract?
So we kind of touched upon this already when we were discussing just entitlements upon termination. But remember what an employment contract is. It's basically setting out what you're agreeing to do, what your expectations are in return for doing that job, and what the employer is obligated and expecting you to do as well. So when you sign on that dotted line, you really want to know what it is you're providing for or what you're agreeing to. So just reviewing the entire document to understand, this is what I say I'm doing and this is what I'm supposed to be getting. And the most basic of what the terms is what an employment contract is. But like we talked about before, very often employers will try to include a termination clause in this contract. And the reason they do that is we've kind of got a bit of a two-tiered system when it comes to termination entitlements in Ontario. Um, as a base, the Employment Standards Act provides that every employee in Ontario is entitled to certain standards, and that includes upon termination. So at a very minimum, you are entitled to a certain amount of notice and severance pay if you are terminated without cause under the Employment Standards Act. But if your employer doesn't very specifically in their contract say that is all we're going to give you if we let you go, we're just going to give you the minimum that we're required to give you, then you might have some entitlements to something beyond that, which what we call common law notice entitlements. And that can be quite a bit more than what the ESA provides. The ESA typically just provides about a week per year of service of notice to a maximum of 8 weeks. And then if you are a long-term employee, so if you've been employed for more than 5 years, and it's a larger company with the payroll exceeding, I think it's 2.5 million, they also have to pay you severance pay and acknowledgement that you're such a long-term employee. So that's another added week per year of service. So really you're looking at about 2 weeks per year under the Employment Standards Act, assuming you have severance obligations. If your employer hasn't specifically said that's all we're giving you, you could be looking at as much as about a month per year of service, possibly even more, because the courts will really look at your personal situation and say, how much notice is reasonable in these circumstances to help you find comparable employment. And so we've seen recently with COVID, the courts being open to an even extended amount of notice in recognition of the fact that it's really not that easy these days to find something comparable. So that's one thing to look at in an employment contract. Does my employer include a termination clause? And where a lawyer can really add some value here is to tell you, yes, there is language here about a termination, but, from the looks of it, is it or isn't it valid? Because it needs to be written in a certain way and provide for certain things in order for it to even be enforceable and valid. The other thing to look at is, what is the schedule? What are vacation entitlements? Is there a probationary period applicable? Which is basically a minimum time where it's kind of like a test period where your employer can see if you're a good fit for them. And during that probationary period, they can let you go without providing you with any specific reasons or notice. And just taking a step back, that probationary period still needs to be consistent with the Employment Standards Act. Meaning if your employer says, let's do a 6-month probationary term to see if we like each other, they still need to provide you with notice of the termination. They just can't let you go without notice if it's 6 months into your employment, because the Employment Standards Act only really provides for the first 3 months to be this period where no notice is required. So I know we're getting a little complex here, but it's always a good idea to basically go to a lawyer, have it reviewed with them. The lawyer will tell you what may or may not be negotiable, what terms may be not necessarily enforceable down the road. Just give you an idea of the lay of the land so you understand what it is you're contracting for. A lot of contracts will include provisions that apply even after you're terminated. So can you compete with your employer? Can you solicit, those clients that you brought into the company? Those kinds of things you're going to want to speak with a lawyer about to find out are these terms fair and are they enforceable?
So let me ask you a follow-up question. If you're in a situation where you've been given the employment contract and you talk it over with your lawyer and your lawyer has concerns about what's in there, and your lawyer says, either negotiates on your behalf or, like, gives you some lines for you to do the negotiation, and the company comes back and said, you know, sorry, no deal. This is the employment offer. Take it or leave it. We could hit another 20 people who want your job just by swinging a cat. Um, what other options do you have to sort of use your lawyer's legal advice to add value in that situation? What are your what's the next best option that your lawyer can help you um, uh, prepare and sort of plan for in a situation like that?
Yeah, and what you're describing is not unusual at all. There is an imbalance of power between an employee and an employer. Um, Quite often, depending on the kind of position you have and the demand for that position, you may not necessarily be in the best position to negotiate. And really, where the lawyer adds value is in telling you this is fair, this is unfair, there's room here where you can negotiate more. And when the employer comes back and says, no, this is it, or we'll change this, but not that, at a certain point, it becomes a bit of a personal decision as to do I accept it or not. But the one thing to keep in the back of your mind is because of this imbalance, which the courts are very aware of, where there is a provision included in a contract that is ambiguous in some way or not very clear in a certain regard, the courts are going to interpret that in favor of or against the drafter of that contract, which is the employer. So any ambiguity is going to be in your favor because there is that recognition of the imbalance of power with how negotiations have gone and who's prepared this document. So it's still very helpful to speak with a lawyer just to know, firstly, a lot of the times employers will include, I'll use the termination clause again as an example, language in there that, they might not be willing to change, but your lawyer will tell you, you know what, this is not even enforceable today, let alone 6 months from now. So maybe you might not have the power to negotiate, but maybe this is not really a big issue because that clause down the road is not going to be enforceable regardless. So it still gives you a lot of perspective in terms of what it is you're agreeing to and what the possible implications are, which is why it's still highly recommended that you get something reviewed by a lawyer or at least get some summary advice.
Thanks. That's really informative.
So going back to estate law, you there's a question that came in some time ago about just the having issues with an executor of an estate. So if you have questions, maybe you're a beneficiary of an estate and you've got questions about what's provided for, and you've got an executor who's just not being responsive or even giving you a copy of the will. Like, what are your recourse in that situation?
Well, there aren't a lot of guidelines in the law in Ontario as to what information an executor has to provide to beneficiaries and when. The executors under the law in Ontario are granted a lot of flexibility to manage estates um, in a thoughtful way, and they're often not held to very specific timelines. A lot of people think that there is a mandatory requirement that within 1 year, an executor apply for probate or an executor distribute all of the assets of the estate. And while the idea of an executor's year, for example, is a helpful guideline to what you can expect from an executor, often there aren't any hard and fast rules about what they do and don't have to do. And what that means is that it's important to one of the reasons it's important to communicate with a lawyer about these things is that a lawyer can help you put in perspective what which of your requests you can expect that the executor is going to agree to, and which of your requests you can expect that the executor is not going to be able to agree to or not simply be capable of fulfilling, and help set your expectations effectively. And then when you're dealing with an executor who's not cooperative, the strategy that we usually recommend to clients, not in every situation is different, we usually suggest, communicating with an executor directly and saying, I would like to receive this and this, um, and I would like to receive it within this time frame. Can you please get back to me? And you send that correspondence in writing, so you have a record that you ask the executor for that information, and you ask the executor to get back to you in a certain period of time. And then if the executor doesn't get back to you, usually the next step in escalating the problem is we send a letter to the executor and we say, we've been retained by this person. This person would like to see a copy of the will, and um, we would like to receive that copy of the will and just a breakdown of what the value of the estate is and an update on what steps you're taking to probate the estate. And we'd like that within a week, please. And then if the executor doesn't get back to us, the next step is we take a little bit more firm tone and say, we'd like to get these answers from you, but if we don't get these answers from you in 7 days, we're going to have no choice but to begin a proceeding in court. When you actually get to court, again, because there aren't any hard and fast rules about what an executor does or doesn't have to do, it's really important to create that paper trail of, on May 1st, I asked the executor to get back to me in 7 days. The executor didn't respond. Then on May 7th, my lawyer asked the executor to get back to her. The executor didn't respond. Then on May 14th, my lawyer said, this is your last opportunity to respond to us. Please give us this information in 7 days or we'll go to court. The executor still didn't respond. By doing that, you're painting a picture for a judge down the line of who was making polite and reasonable requests and who was impolitely refusing to communicate. And that will help paint a picture of you as the person who's being reasonable and the executor is the person who isn't being reasonable. And that's very important in estates when there aren't any hard and fast rules about what the executor has to do and by when, because the court will generally hold the executor to the standard of what is a reasonable person going to do in this situation. And even though there are many people who, in the law as in life, don't respond to your messages, don't answer your calls, they're just impossible to get a hold of. The court expects as a general rule that when you ask somebody who has some kind of a legal obligation to you a question, you're going to get an answer in a reasonable time frame at the very least. And if you ask for a piece of information that isn't secret and that it doesn't harm the executor to provide to you, the executor should provide you with that information. There's no reason for an executor to withhold information from you that, doesn't harm the estate in any way. If you are a beneficiary and you presumably have a right to that information. So just building up a case with your lawyer's assistance of what questions you asked and why those questions were reasonable and why here's where the executor didn't respond to me and didn't provide an answer to my eminently reasonable question. You start to build a case for you being in the right and the executor kind of being in the wrong. And that will help bring the court on your side if some more lengthy estate litigation is going to follow.
It's funny how often that principle applies, where building your case, politely asking over and over again, really sets the tone of any future litigation, where a judge is shaking their head thinking, why are we here today? This was such a reasonable request 6 months ago. So it really holds a lot of value.
Do you find that that's true with employment matters also?
All the time. I mean, especially when you've got complaints in the workplace where, an employee is not being very nice to someone else, or you've asked for accommodations and it's something that warrants at the very least a response or an explanation. And where there was an opportunity to resolve something early on, and there were repeated opportunities along the way, and someone just chooses not to, the courts really do eventually come down very hard on those types of cases, whether it's, it might not necessarily be the merits of the case, but somewhere down the line when you're arguing costs or why it had to go as far as it went, it's going to come up.
One particular nuance I want to just add to my answer, I just thought about during your response, and I reckon that this is also applicable to employment law, is that it's super important to bear in mind that if you have specific concerns with the executor, specifically about money missing from the estate, and you write to the executor and ask a question about, like, hey, what happened with this bank account? And the executor didn't get back to you, you have to take action on those concerns that you have within a certain frame of time. You generally have, if you have a question about a claim to an amount of money that the estate owes you, in most cases, not all, but in most cases, you have 2 years from when you become aware that the estate owes you money to pursue that claim in court, particularly after the executor has been appointed as the trustee of the estate by the court. So when you start that chain of communication with the executor, raising questions, asking for answers within a certain frame of time, it's important to, and this is another thing that your lawyer can help you with, set an internal clock that now that I've raised this question about, hey, where's the money? You have to take some action on that within a fixed time frame. You usually have 2 years, but especially because with estates, often money leaves, and often it's very hard to track once it's gone out the door, and it's important to not let the money go out the door in the first place. Once you're starting to have suspicions, it's important to act on them right away. I don't know if there are ways in which there are similar situations in employment.
Yeah, like the 2-year period you're talking about, we've got, again, it doesn't apply in every case, but there is something that's called the statute of limitations, which is how quickly do you need to go to court when you've got some kind of claim. And the general statute of limitations, especially in employment law, tends to be about 2 years from the date giving rise to your claim. So in employment law, that would be the date possibly of your termination. So yes, you can follow up over and over again, but at a certain point, you're going to want to be sure that you've actually started a legal proceeding where someone can make an order in your favor within that time frame. But speaking of time, it looks like we're out of ours. I think we always have way too much fun with these questions and lose track of time. But we did want to thank you all for joining us. We have a lot of fun getting to your questions, and it gets us thinking and learning, and it's always a good time. But thank you so much.
Thanks a lot, Simran. It was great to see you.
You too. Take care, everyone.
Thanks, everyone.
Join us for Legally Adulting.
Adulting is not supposed to be easy.
What are the questions and concerns that we as young people have about living through a pandemic?